Okay, we're on the record in the matter of the people of the state of Michigan versus Justin Dwayne Morris. File number 22-02838 FY, council appearance.
Morning, your afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the
Good afternoon, Your Honor. Jacob Sarge, support Assistant Public Defender on behalf of Mr. Morris. He's present. He's at council table. Be seated.
How are you, Mr. Morris?
Good. Yourself?
I'm doing pretty good. Today's the date and time that's set for preliminary examination. Are we ready to proceed, or do we have any preliminary matters we should address?
people are ready to proceed, Your Honor.
I just asked for the standard sequestration order, Your Honor.
Okay, how many witnesses are you calling?
Two, Officer Kristen Washington and Detective Robert McBride.
Okay, sequestration order is granted. You can call your first witness.
People call Officer Kristen Washington. No, I'm gonna have to wait on some.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do, Your Honor.
Thank you. You can have a seat there. Can you state your first and your last name and spell both of them?
First name Christian, last name Washington. Christian spelled as Christian. Washington spelled as Washington.
You can see.
Thank you. Good afternoon, Mr. Washington.
Good afternoon.
Where are you currently employed?
I'm currently employed at the Lansing Police Department,
And what is your title there?
police officer.
Officer Washington, how long have you been employed there?
I've been employed there 5.5 months.
So were you employed with the Lansing Police Department as an officer on October 18th of this year?
I was.
And on that day, did you respond out to 554 Tisdale Avenue?
I did, yeah.
And is that in Lansing? Is
Yes, it is.
that in Ingham County?
Yes, it is.
While there, did you make contact with an Ashley Nebraska? Did
I did.
you speak with her? Is
Yes, I did.
that her residence?
Yes, it was.
And did you observe any injuries to Ms. Nebraska?
I did.
What were those injuries?
She had bruising on her neck, and she had a small cut on her upper lip, and she had bruising on her arm as well.
No photographs were taken with those injuries?
Yes, there was.
Now, I'd like to approach the list of marked people who proposes it's 1 through 3.
Just for the record, I have the opportunity to show the proposed exhibits to Mr. Butcher.
Thank you. You may approach.
Officer Washington, can you please describe what is depicted in those exhibits?
This one indicates, the one I'm looking at indicates her cut on her upper lip.
And what number is that?
That is,
Would be in the yellow tag.
I believe it's 1197 or 11. I'm having a hard time reading it. Is it? Oh, depiction 11, exhibit 11.
We just take notice, it is marked as 1 with the reporter's signature
Okay.
initials
Oh.
after it.
Sounds good. Thank you.
The picture 1.
And could you please look at your proposed exhibit 2 and say for the record what that depicts?
It depicts a bruise on Nebraska's arm.
And if you can look at the proposed exhibit number 3.
It depicts the other bruise that was on her arm as well.
And were those on same arm or different arms?
These are on different arms.
Thank you. And do those pictures accurately reflect the injuries you observed that day?
Yes, they do.
Your Honor, at this time, I seek to admit people's proposed exhibits 1, 2, and 3.
Any objection?
Yes, Your Honor, for lack of foundation.
Do you want to respond?
I believe there's been sufficient foundation as these injuries accurately depict the injuries that he observed on Ms. Nebraska on that day.
Why don't you expound on what foundation you think was not laid properly?
Your Honor, we don't know who took the pictures. We don't know when they were taken. We don't know from what angle or important information along those lines. There's no testimony about any metadata as related from the pictures themselves. So on those grounds, I would object. Thank you.
Okay. Not really interested in metadata, but if you want to tell us who took the pictures and when.
I can ask that question. Officer Washington, were photos taken of these injuries?
Yes, they were.
Who took those photos?
I took the photos.
Those photos you took?
Yes, they are.
I seek to admit those proposed exhibits 1, 2, and 3.
Okay, you took those on the date of the incident?
Yes, I did.
Okay.
Your Honor.
People's exhibits 1, 2, and 3 admitted with the objection.
And I would seek to publish them with the board. at this
You
time.
may.
Now, you spoke with Ms. Nebraska, correct?
I did, yes.
As a result of the conversation with her, you determined that an assault had taken place?
I did determine that, yes.
Did you determine that assault was domestic in nature?
Yes,
Do those injuries that you observed seem to match up with what you were told?
yes, they do.
And were you told roughly how long ago the assault had taken place when you were speaking with her?
Yes,
And what kind of time frame are we looking
roughly approximately half an hour.
at? And Ms. Nebraska was the victim of that assault?
Yes, she was.
Here, I seek to move forward on the MCL 768.27C and elicit statements from the victim to this officer. I believe all of the requirements have been met.
Mr. Sykes.
Thank you, Your Honor. I will be objecting on the grounds foundational requirements that have not been met. There's questions about the credibility of these statements, that they're all hearsay, that they potentially would infringe on my client's rights as it relates to cross-examining the statements, because if they're going to bring it into the officer, certainly would not have the opportunity to more directly question the source of the alleged statements herself.
We know it's hearsay. That's the whole point of the statute.
Understood, Your Honor.
Sounds like the objection is to the existence of 27C and not as to whether 27C.
Correct. That's what I was gonna ask. Is it the objection as to 27C, or you still, is it a foundational?
It's a foundational
Okay.
argument, which I'm just trying to raise.
Got it. Okay. So, and your foundational concern is where that credibility has not been established.
Yeah, there might have been bias or their fabrication for the alleged statements. We don't have foundational requirements in order to explore that. And
Okay.
lack of foundation has been so far as in terms of testimony prior to potential incident.
Okay, and I'll allow Mr. Pfeiffer to further question the witness to lay further foundation as to whether or not the testimony is credible.
Thank you.
Did she say the name of the individual who had assaulted her?
May I say the name?
Did she say a name?
Yes, she did.
And what was that name?
It was Justin Morris.
Ms. Morris. Did she say how that Mr. Morris was related to her?
Yes, she did.
And how was that?
She stated it was her boyfriend of approximately 3 years.
Did she say if they had any children in common?
Yes, she did.
And what was the answer?
She said they had a child in common, Autumn Morris.
Did she say if Mr. Morris was supposed to be at her residence?
Yes, she said. What do you mean by supposed to?
Well, Your Honor, so the hearsay is coming in already, so has the hearsay been ruled to be admissible? Well, because the officer kept on saying she said in terms of the responses.
So you're objecting as to the most recent question, or just in general as to the line of questioning? And his
The
response.
responses have all been hearsay because he keeps on saying she said. So I suppose I'm going to object to this line of questioning unless Your Honor has already determined that it should come in under 768.
Okay, well, I don't see how else he's gonna get any foundation without finding out more information, not being offered for the truth of the matter asserted, but to lay the foundation. So at this point, I'm going to find that foundation is sufficient. You can proceed under 27C.
Thank you, Your Honor.
Thank you.
Did Ms. Dabrowski tell you if Mr. Morris was or wasn't supposed to be at her residence?
The Nebraska told me that he wasn't supposed to go.
And did she say why?
because he had a PA 53 violation. She had a PA 53 violation against him.
Now, what did Ms. Nebraski tell you happened during this assault?
Ms. Nebraska told me that it was early in the morning. She told me that Morris gets upset when their daughter cries early in the morning. Nebraska told me that she stated that his father called inquiring if he was going to come to work that day. So she had the phone initially. She walked over to Mr. Morris and was going to give him the phone. That's when, as she approached him, he was in an upset manner, and then when he started calling her names, and then grabbed her and threw her to the ground. Nebraska told me that from this, while she was on the ground, Mr. Morris positioned himself behind her. Reached his arm around her neck and started strangling her.
And did she say this impacted her ability to breathe or consciousness?
Yes. She stated this was one of the 2 times that he strangled her, and the first time she had trouble breathing.
Okay, so he's on the ground, got his arm around her neck, and she had trouble breathing as a result.
Yes.
What did she say happened next?
So while he's strangling her, while Nebraska said while Morris was strangling her, he told her that he's going to put her to sleep. And during this time, she is pleading and begging him for him to let her go. At this time, she bit his arm that was around her neck in an attempt to let herself go. Nebraska told me later on that she was able to free herself from his grasp and she crawled into the kitchen.
So she was able to get away and is in the kitchen. What does she say happened when she got to the kitchen?
While she's in the kitchen, this is when she said she made her way to the hallway. And in the hallway, Nebraska told me Mr. Morris followed her and got her in the same position of strangling that she did the first time. And this time is when Nebraska told me that she lost consciousness.
So he once again got his arm around her neck.
Yes.
And as a result of the pressure, she lost consciousness.
Yeah.
What did she say happened when she woke up?
When she woke up, Nebraska told me Mr. Morris then stopped her or hit her. She couldn't remember if it was an open hand or closed hand, but she does recall him making contact with her. Once.
Did she? So what did she say happened after he slapped her?
So after he slapped her, this is Nebraska told me Mr. Morris became remorseful. He started apologizing and trying to give her hugs. Nebraska then stated that Mr. Morris said he was going to use the bathroom, and this is when Nebraska confirmed with Morris that if it was okay for her to go sit on the porch, and they both agreed that's an okay thing for her to do.
She had to ask for permission.
She did have that.
So did she go out into the porch?
She did go out onto the porch while Mr. Morris went to the bathroom.
And what did she say she did next?
When she made herself outside the residence and on the porch, she then went to her next door neighbor, Mr. Johnson, and knocked on his door so that she could call him.
Did she not have a phone?
She told me that during the altercation, the phone was broken.
Did you observe her phone?
I don't.
You know, if you took a photo of the phone?
I didn't. There was no photo of it.
Here, I'd like to approach the witness Wilson Marks to propose exhibit 4.
We approach.
Sir, just handing Lewis Marks to propose exhibit 4. What is that picture pic?
That would depict Nebraska's phone.
So there was a photograph that was taken of it?
There was.
Is that?
I'm going to object because of lack of personal knowledge. You just testified that there was no phone that was taken. The image of phone was taken.
I believe I'm allowed to impeach my own witness.
Proper impeachment, Your Honor. You testified very clearly there was no phone.
What is the improper impeachment? He just refreshed his recollection with the picture.
object on lack of foundation here, because obviously.
You're objecting to him impeaching his own witness. It's actually to your benefit that he impeaches his witness, no?
Objecting the grounds of improper impeachment.
Okay, objections overruled.
Thank you. So I'll ask the question again. Do you remember if you observed your phone that day?
I did observe the phone. So
Okay, and did you take a picture of the phone?
I did that. Just
Okay. And so does that accurately reflect the phone that you saw that day?
yes, it does.
Your Honor, I seek to admit close exhibit 4 into the evidence.
Any objection?
Thank you, Your Honor. I object to lack of foundation.
Objections overruled. If People's 4 is admitted,
I seek to publish it to the court at this time.
you may.
So it was, she was able to get someone to call for help when she went to the neighbor.
Yes.
Did you attempt to locate the defendant?
Yes, we did.
And did you actually locate him?
Yes, we did.
Was that at 1024 North King Boulevard?
Yes, it was.
How did you know to go there?
During my interview with Mr. Nebraska, she told me that he wasn't at the residence of the Tisdale residence, that he would be inside the residence of an individual named Selena Morris. And so we looked Selena Morris up on Lean and PLO to locate her residence. And then
What is TL?
PLO it was something that my co-training officer took part in. I'm not allowed to hold it.
Is that, what is it?
It's a software that's used to you type in a name and then give you their contact information, their residency history, things like that.
And it's a law enforcement software?
Yes, yes,
And that's I got the 1024 North King Boulevard.
yes, it was.
So did you go to that address?
Yes, we did.
And did you make contact with someone you later determined was Justin Morris?
Yes, we did.
And was that individual arrested there?
Yes, he was.
Were photographs taken of him and
Yeah.
any injuries you might have?
Yep, they were.
Your Honor, I would like to show the officer proposed exhibit 5.
May approach.
Officer, what is proposed exhibit 5 that I placed in front of you depicting? It depicts Mr. Morris and an injury to his forehead.
And does that accurately reflect the man that you arrested and identified as Justin Morris on that day?
Yes, it does.
Your Honor, I'd seek to admit proposed exhibit 5 into the evidence.
Any objection?
Yes, Your Honor, like the foundation.
Objection overruled.
Thank you.
I'd seek to publish it to the court this time. Thank you. Now, that same individual you arrested that day that you identified as Justin Morris, is he here in the courtroom?
Yes, it is.
Could you please identify where he's located? Maybe something he's wearing differentiates him from the other people in the courtroom?
He is wearing navy blue scrubs. Next to the defense attorney.
If the record reflects who's identified the defendant.
Any objection as to identification?
Yes, Your Honor, lack of personal knowledge, lack of foundation.
I want you to explain your objection.
Okay, sure. The officer testifying here would not have had any personal knowledge as to what Mr. Morris would have looked like. He made it very clear based on the testimony that he was relying entirely on Ms. Nebraska's statements earlier. There's no description of what Mr. Morris looked like. There's no date of birth information. There was nothing else. He simply plugged in an address, and now he's here claiming that he can testify Mr. Morris. Based on what?
This is, I think he was basing it on this picture here. Did you took this picture, officer,
Yes, I did, Your Honor.
on the date of the alleged incident?
Yes, Your Honor.
And this is the person you identified as the person in the court today that is Justin Morris?
Yes, Your Honor.
But where would the identification be in terms of Mr. Morris
You
specifically?
mean as the description as to how he came about?
Correct.
Okay, and so I believe you asked, but did Mr. Nebraska give you a description of the defendant?
She didn't give us a description. When we looked him up, when we used Lean and TLO, it came up with this picture.
It came up with his picture,
Yes, Your Honor.
and this is not that picture though, correct?
That is not that.
Okay, but does this match that description?
Yes, it does, Your Honor.
Did she give you a date of birth or anything for him, or
Yes.
just a name?
Date of birth, name, phone number, where he's supposed to, where his residence.
Okay, and the information you looked up in the law enforcement software had that same date of birth information?
Yes, it did, Your Honor.
Okay, objections overruled.
Thank you.
You were there for the arrest of Mr. Morris?
I was.
Was there any other officer there with you?
Yes.
And who is that officer?
It was Officer Erica Hackman, Officer Baker.
Do you know if Mr. Morris made any statements to those officers?
Objection, lack of personal knowledge.
That's what
Other
I'm
officers.
asking, is if he has personal knowledge.
I don't.
And that's the answer. Just one moment.
No problem.
This time, people have no further questions for this witness.
Thank you. Cross examine.
Thank you, Your Honor. Just briefly, officer. Best of your recollections, how long approximately did it take when you first talked to Mr. Brasky and until you ultimately talked to Mr. Morris?
Approximately. So from talking to her at at Tisdale and then moving up to Martin Luther King,
Right.
half an hour to 45 minutes.
Okay.
Approximately.
And when you first responded to the residents, how was Mr. Brasky's state of mind at the time? Was she very upset? What was her kind of state of mind?
She was upset, crying, and struggling to talk.
Did she have any alcohol in her breath?
Not that I know.
To the best of your knowledge, approximately what time of day was this?
What time of day?
Yeah,
Approximately 10 to 10:30 in the morning.
in the morning. Did you observe anybody else in the house at the time?
Inside the neighbor's house or the Tisdale?
The Tisdales.
There was nobody else in that.
So you didn't observe any children in the residence at the time?
I did not. She was holding, when we first saw her, she was holding the child inside the neighbor's house.
Okay.
But when we went over to check her house for Mr. Morris, there was nobody.
So when you first responded, you didn't go directly to her residence, you went to another location?
Yes, we were getting waved down by the neighbor,
Okay. You recall the name of the neighbor?
Mr. Johnson.
Johnson. And was this location by, was it across the street? Where kind of, you said
Direct-
neighbor, right across the street?
Directly next door on the same street.
And to the best of your recollection, approximately a half hour from when the first call came in, they got over there?
Approximately, yes.
Okay. And in terms of your interactions with Mr. Brasky, approximately how long did that whole process take?
Say approximately an hour.
And then what address again did you ultimately find Mr. Morris at?
1024 North Martin Luther King Boulevard.
Okay. And how far away was that from Tisdale location?
It was about half an hour away, approximately.
about a half hour away. And did Ms. Nebraska at the time mention anything that might have impacted her memory at all, like mental health history or anything along those lines?
She did not.
Okay. So when you had your initial interactions with Mr. Moore, did you observe any other injuries other than just the wound on the head?
I don't remember.
Okay. Nothing further, Your Honor. Thank you.
Thank you. Let me redirect.
Yes, Your Honor. Briefly. So you responded out to 554 Tisdale Avenue, which was the neighbor Johnson's residence, correct?
Yeah.
And then after speaking with Ms. Nebraska there, you went to her residence, which was next door, correct? And was that 548 Tisdale?
Yes, it was.
And so that is her residence.
That is correct.
And that's where the assault took place?
Yes, it was.
I have no further questions. Your Honor.
May this witness be excused?
He may.
Okay, officer, there is a sequestration order, so you're not to discuss any portions of your testimony with any of the other witnesses, okay?
Yes, Your Honor.
Thank you. You may be excused. You can call your next witness.
People will call Robert McBride.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, ma'am.
Thank you. You can have a seat.
I know this wasn't made for me.
If you can, feel free to pull that out, right?
We went through this
We
last
have,
time.
listen,
There we go.
but better days are on the horizon. Okay, we'll get a better suitable stand at some point. Nonetheless, please state your first and last name and spell both of them.
Robert James McBride, ROBERT,
Proceed, counsel.
Good afternoon, Mr. McBride. Where are you currently employed?
City of Lansing Police Department.
And what is your role there?
I'm a detective investigating domestic violence claims.
So Detective McBride, how long have you been employed there?
I've been employed with City of Lansing for 24 years.
24 years. Now, do you have access to the jail call system?
Yes, Securus.
Part of your work on this case, did you discover calls between, or listen to calls between a Justin Morris, from a Justin Morris?
Yes,
And were those to a number that was associated with an Ashland, Nebraska?
yes.
Now, secure system, for some numbers, is there an actual ID associated with it?
Sometimes you can click on the recipient's phone number and it will bring up the name of the person that they're actually calling.
Your Honor, I'd like to present the witness list remarks to proposed exhibit 6.
You can proceed.
Thank you. Now, Detective McBride, can you please briefly describe what's marked as proposed exhibit 6?
This is a jail call log. It shows the inmate name, which would be the account holder, the incarcerated person at Ingham County. And it has a target phone number, and That is a phone number that is associated to Miss Nebraska, Ashley Nebraska,
And does it say the name of the inmate who's making those calls?
Justin Morris.
Thank you. Your Honor, at this time, the people move to admit the proposed exhibit 6.
Any objections?
Yes, Your Honor, objection on lack of foundation.
What further foundation were you seeking?
Well, Justin Morris is a somewhat common name. There's has been insufficient foundation to connect this particular Justin Morris with these alleged accounts, and further insufficient foundation to connect Mr. Brasky with any sort of alleged number here. So due to lack of personal knowledge and lack of foundation, I will be objecting. to
Okay,
this exhibit.
maybe we can get some more foundation as to how we connect this Justin Morris to this jail call or these jail calls.
Is that from the Lansing City Jail,
This is the Eaton County Correctional
Okay.
Facility.
in County Correctional Facility? Is that the jail located in Mason?
Yes,
Does it actually say the name Ashley Nebraska as the target of these calls?
under call to 517-574-6161. It does list her name and address.
And what is the time frame of these calls?
It looks like it starts October 30th up until November 8th.
I think that is sufficient foundation for the admission of this piece of evidence.
Yeah, objection is overruled.
Thank you, Your Honor.
Seek to admit to the court, this time, publish it to the court this time.
Yes.
Now, you reviewed these calls?
Yes. Not every call. I've reviewed 5
calls.
recently.
And were you able to determine who these participants were in this call based on the contents of it?
The recipient would be Ms. Nebraska, and the person originating the call will be Mr. Morris.
And that was based on the actual content of the calls?
That's based on the content.
What led you to those conclusions?
The conversation and about dismissing the case and the information that's provided on the jail call law. Unless another inmate were to provide you with their PIN number to make calls, which would actually be not something they're allowed to do, he should have been the one making the calls using his PIN number.
Did the inmate making these calls make references to Mr. Morris's case with Ms. Nebraska?
Yes.
Now, for our court today, I played for you a portion of what's marked Appeals Proposed Exhibit 7A and 7B. Those being jail calls from, recordings marked as jail calls from 11/3/22 and 11/8/22. Do you remember hearing those?
Yes.
Now, those snippets that I played, Appeals Proposed Exhibit 7A and 7B, did those match the recordings that you reviewed?
Yes.
Your Honor, at this time, I would seek to admit Appeals Proposed Exhibit 7A and 7B.
Any objection?
Thank you, Your Honor. I'm going to object on lack of personal knowledge and lack of foundation. Thank you.
Okay, I think that he's laid sufficient foundation. He explained exactly how a phone call should be made using a PIN number of that inmate, and that the inmate's not at liberty to share the PIN number, and he's identified that these calls were associated to this inmate's PIN number. In addition to that, he's discussed or laid foundation as to the nature of the conversation relevant to a case pending and not appearing in court. Talk about allegedly Justice Morris pending case today. So your objections over.
Thank you, Your Honor.
So Appeals Proposed Exhibit 7A and 7B are admitted.
They're admitted.
Now, Your Honor, I didn't have any further questions for this officer. I would ask that after the question is done, I'd be allowed to publish these to the court, play them for the court without his needing to be here and sit here.
Sounds good. Cross examine.
Okay. So prior to listening to the calls, did you ever listen to a phone call or had any conversations with Mr. Morris yourself?
No, sir.
Okay, how about Ms. Nebraska?
No.
So at this point, you cannot testify truthfully, but you could actually identify the voices.
I am not a voice analyst, sir. No.
Okay, thank you, Your Honor.
Thank you. Any redirect?
No, Your Honor.
Thank you. Detective, you may be excused.
Thank you so very much, Your Honor. Have a great day, Your Honor.
Robert.
You too.
Thank you.
Okay, and no other witnesses at this time?
No, Your Honor.
Okay, you can proceed with your exhibit.
Thank you, Your Honor. And I'm going to start People's Exhibit 7A.
Being recorded and may be shared with law enforcement for prosecution purposes.
I'm going to skip to 3 minutes. Wow, I can't read it up there. I'm going to be moving to the 3-minute mark.
Dude, why did you schedule that shit in your name? It pops up Ashland, Nebraska. So I don't know if I get in trouble or not. You just need to try to put it in someone else's name.
I was gonna just show Autumn. Well, then at least.
Oh, what?
if
The
you
YouTube
got it.
tweaker?
I mean, yeah. So I want.
They're telling me that I should not I should not answer. They said I shouldn't do that video visit day because I get in trouble, you know. Even like the messaging, they said I can get in trouble that way too for tampering with the witness.
All right, then don't do it.
You can cancel it and then just put a different name in, Amber Morris or something. You don't have to show your ID, do you?
Yes,
You do?
yes. That's what I was trying to get Selena.
Well, call Sissy and let her know. You can cancel the visit, babe. I just don't want to get in trouble. You know
I
what I'm
won't
saying?
get my money back.
You won't?
No,
I guess if you just put Autumn on there, I mean, I don't
that's
care.
what it's gonna do.
And then you
At
can
least,
talk in the
I just want
background.
you to. I just want Autumn to see you.
Yeah, yeah. You could just put Autumn where she can see me, and then you could talk out of the picture or something, you know.
Yeah, that's what I was gonna do.
Oh, all right. Well, anyway, and you know it's at 8 o'clock, right?
Maybe show my ass a little bit.
Huh?
Maybe show my ass a little bit.
I know. That's what I was hoping, dude. But fuck. Because right at 8, everybody will be locked down. I was hoping you show a lot more in your ass. I was trying to get a freak show out of this fucking deal. I miss you, bro.
I miss you so much.
They keep telling me as long as Ashley doesn't show up that they have no case. And they're just going to keep me here for 5, 6 months and throw it out, you know.
Yeah, exactly. No,
And
I
every court date, my bond's going to go down and down and down and down.
And it's just gonna be like the other one that you had, and then they gave you a PR bond.
Yep, that's exactly what they're gonna do.
I know.
Pausing at the 5-minute, 13-second mark. I'm now pulling up People's Exhibit 7B.
This call is being recorded and may be.
This is the call from November 8th, 2022, and I'm going to the 6-minute mark.
That's coming up though. Well, in 2 weeks.
That's a month away. I just don't know what to do. Some people tell me that you should show up to court, and some people tell me that if no face, no case. And like I told them, they're like, "What are you gonna do?" I'm like, "I don't give a fuck. There's no way you're gonna stop me from calling my baby mama and seeing how her and my kids are going in the middle of the
Exactly.
I don't give a fuck what you guys say. I will violate it every time. You know, it's my woman. You know, I'm worried about her.
I know. That's why I said like I don't get how they.
Pausing at 6 minutes 30 and going to 8 minutes 50.
Yeah, almost.
What?
Yeah. Yeah. I got wake up with my nose and my arms every day.
Did you get my letter yet?
No, I haven't got no letters. I don't think they're
I wrote you 3 postcards like on
Are
Friday.
you gonna give me some? I know it's hard for you. I can wait, baby, but just look out for me. Like I don't. For God, I'm only calling that number, the other number. All right.
Yeah, it's just hard. Text now is just not like.
Don't say that because that's the first thing Preston. Well, he told her he can't text now. But he was a bitch. I wanted to beat his ass for it. For real, I did. But I went to court and he's like, well, I got 7 calls from Mr. Morris speaking to Miss Nebraska. I'm like, shut the fuck. My lawyer's like, dude, keep your cool, keep your cool. It's all right, it's not the end of the world. I'm like, God damn, a little Poindexter motherfucker. I wanted to snatch him up over the fucking.
Is your attorney cool? Like, is
He's
he?
cool, but he's mad at me because I keep talking to you. And I'm like, I told him, I don't know what the fuck to tell you, but I'm not going to stop talking to my baby mama.
Exactly.
You can lock me up 1,000 years. You know, I don't give a fuck. I'm going to keep talking to her, you know?
I miss you so much. I miss you so much. I want to see you so bad.
All this shit ain't this bullshit to keep me there when I get out and keep me in the same fucking cycle, dude. I want to go with my GED, but everything's 7 weeks up. Dude, I haven't got a haircut. You should see me. I almost got a beard.
I want to see you so bad.
You should see, dude. I know you could set up motherfucking.
Selena won't do it. Like if I could, it's so cheap. Just do it, and she won't do it.
Well, don't do it this way. Have you ever do it? You ever got an ID?
She hasn't been around. I don't really want them around. But
I know that, but someone's got a fucking ID. Call Breeze on fucking Facebook or something. Somebody's got a fucking ID to where we can do it. It just can't
she's
be.
with someone else. She's not with Jerry anymore.
Pausing at 10 minutes 46 and going to 12 minutes.
Schedule them. If they'll let me do it, I'll just do it. I don't give a fuck. That shows to them that you're not scared of me either, because in that senior report that you reported that I tried to choke you with a belt, and that I scared the hell out of you, like you feel like your life's in danger. That just proves my point that you're not, you know, that you're not scared and your life ain't in danger if you're still calling me, wanting me to be with you. You know what I'm saying?
This call is being terminated. No third-party calls are allowed.
And that's the end of Exhibit 7B. And at this time, the people will rest.
Thank you. Is the defense calling any witnesses today?
Oh, Your Honor, thank you.
Argument.
Your Honor, through the evidence under MCL 768.27C, statement by Ashley Brasky to the officer, it is clear that the defendant assaulted her, that the defendant put his arm around her neck to the point where she had difficulty breathing first time, and then she was able to get away and he did it again to the point where she fell unconscious. Testified there was a domestic relationship. As a result, I would ask the bind over on count 1, assault with intent to grave bodily harm, less than murder or by strangulation, as the wrapping his arm around the neck and applying pressure, impaired her ability to breathe. The misdemeanor count 2, this was a domestic assault. I'd ask that you add additional count assault by strangulation for count 3, because there were 2 separate incidents of strangulation in this. That code for that being 750.84. Then I would ask that you add additional count 4, that being witness interfering. Pack code for that being 750.1227A. As the detective testified, listening to the calls between the defendant and the victim, he talked to her about not coming to court. And as part of the reportings that we heard, he was telling her, well, if she doesn't show up, they've got no case, it's going to get thrown out. I believe that based on the detective's testimony, after his review of these phone calls, there is sufficient evidence for the additional count 4 of witness interfering. He's trying to get her to not show up if the case is dismissed. And based on this testimony, Your Honor, I'd ask that you bind over as requested.
Mr. Starks?
Thank you, Your Honor. I respectfully, on behalf of Mr. Morris, the defense would object to bind over on all of these proposed counts, especially the added counts, Your Honor. The statements here, of course, were produced through hearsay. Mr. Brasky did not testify. There was a significant gap in time between when the officer first responded until when Mr. Brasky actually allegedly spoke to the officer further. There was additional discrepancies in terms of where those interviews took place and what time frame. There are questions about the credibility of those statements. And further, Your Honor, at least initially anyway, they were mostly just being brought in for foundation. So it's insufficient weight in terms of the statements. And for those reasons, we felt the allegations of the assault by strangulation counts should be dismissed. The testimony was not clear, especially as it related to any second alleged strangulation. That's the added count 3. Granted, a misdemeanor would piggyback along, Your Honor. So, but obviously there's credibility issues with the statements in general. But lastly, in terms of the request to bind over on witness interference, Your Honor, this is a somewhat unique and complicated count, Your Honor, because it delves a lot further into something well beyond just simply an allegation of contact between the parties. It has very specific elements that there must be at least some evidence for the purpose of bind over to be shown. It gets basically almost into like a specific intent crime in terms of that kind of classification of it, albeit Michigan is largely kind of gone away from a lot of that specific language. But bottom line here is there are very specific elements as it relates to witness interference. And what you heard here was at best, like most favorable to the prosecutor, some banter between two people who were engaged in some type of relationship. But in terms of the actual intentions, and most commonly, there's a theory attached behind these witness interference charges, such as threats, such as bribery, such as some type of intention behind the acts as to why the people believe that there's a sufficient basis for that particular count. Not hear that any of that here. Even in a light most favorable, assuming those alleged statements actually were Mr. Morris's, there's no threats of any violence against Mr. Brasky if she didn't show up. There's a conversation back and forth, but clearly based on the tone of Mr. Brasky, she did not appear to be concerned at all, or on the contrary, her statements, the portions that were produced, she seemed to be very engaging. She seemed to be happy. She seemed to be having a pleasant conversation and did not, based on those statements anyway, appear to be influenced at all. And further, there were no offers of any bribes. There were no offers of retaliation if she did not allegedly show up for her court dates. On the contrary, at one point, Mr. Morris's alleged statements was, "I don't know." So, this goes beyond just simply an allegation of a conversation between a potential witness and a accused person as it relates to this specific count. The prosecutor needs to show more other than just simply produce a call alleging that the two of them had a conversation for that particular count. Granted, certainly there's arguably grounds that the prosecutor could try to argue there's a PA 53 violation. Sure, absolutely. There's certainly some grounds for an argument along those lines, but specifically as it relates to allegations of witness interference, which go just beyond just a generic conversation, the prosecutor has failed to introduce sufficient evidence or bind over on that added count. Thank you.
Bribery and intimidation are different than interfering, Your Honor. The officer testified that based on his review of 5 of the calls that were made, only 2 of which I played here, he talked to her about getting the case dropped. He even says to her, the call we played, "They keep telling me that if Ashley doesn't show up, they've got no case. That shit will get thrown out." And it says in the other call about how everyone's telling him, "No face, no case." Meaning she doesn't appear, there's no case. Domestic relationships have that inherent danger, which is why the courts every single time for domestic cases apply the no contact order, because there is that inherent enhanced risk of witness interference because it's already about power and control. In this case, he brings it up. He talks about it. He says, if you don't come to court, it will get thrown out. He's interfering with a witness coming to court, Your Honor. Doesn't need to be threats, doesn't need to be bribery. And doesn't even need to be successful because an attempt is built into the statute. He just has to try. And it is very clear from those calls and from the testimony of Officer McBride that he tried. I'd ask that you find over in the added count 4.
Okay. Mr. Morris, today was the date set for your preliminary examination, and the burden is on the prosecution. It's a relatively low burden. They only need to establish that there's sufficient probable cause that a crime was committed, and sufficient probable cause to charge you as committing those crimes. And that probable cause burden is just more evidence than mere suspicion, not a lot, just more than that. It's not to be compared to what the standard would be at a trial, which is on the burden of the prosecution to prove beyond a reasonable doubt then. This is a flexible burden here. It's based on common sense standard. And the court is the only and the sole determinant of credibility here. And so we had here the testimony of 2 witnesses. First witness being Officer Christian Washington, who testified that on the date of October 18, 2022, at the area of 55, well, he responded to the area of 554 Tisdale and Lansing in response to a domestic complaint that what later was determined took place at 548 Tisdale Ave, which is a neighboring address. Located in the city of Lansing, Ingham County, state of Michigan. Testimony was elicited under MCL 768.27C. The court made the determination that that information was credible. There's an argument as to the timing in which that communication between the officer and the victim and then the officer and the defendant took place, and that whether or not it was substantially long enough or created a long enough time frame. I think the testimony was that the officer spoke with the victim about a half an hour to 45 minutes before he made contact with the defendant. I find that to be relatively close in proximity as it relates to investigating a domestic complaint. We're talking about a matter of minutes, not even a full hour, based on what the officer alleged to have observed when speaking to the victim. He testified that she was upset and crying, and that she was struggling to talk, but that she also had some bruises, I think, on her arms. There was bruising on her neck and a cut above her upper lips. And so the court found that information to be trustworthy and reliable, and so admitted under 27C. And so she identified or told the officer about an incident that occurred that date, indicating that the defendant is her boyfriend, Justin Morris, of 2 years. They had 1 child in common named Autumn, and that the defendant gets upset when the baby cries early in the morning, that the defendant's father had called to see if that the defendant was coming to work that day, that she was attempting to give him the phone. When he got upset, threw her on the ground and strangled her the first time, was particularly what the argument says. I know there's an argument that it was unclear as about there being 2 separate instances, but I think it was extremely clear. So I think officer indicates that there was a strangulation on the first attempt after he threw her on the ground, and that he said, "I'm going to put you to sleep." She bit his arm so that she could get loose. She crawled into the kitchen. Officer testified the defendant followed her into the other room, and that he, for the second time, strangled her, and that this was the time in which she lost consciousness. And that when she woke up, he hit her. He also testified that during the altercation, the phone was broken. Defendant is charged with 1 count of assault with intent to do great bodily harm less than murder or by strangulation. According to the criminal jury instructions at the time of trial, the people need to prove beyond a reasonable doubt, first, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, we could consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means physical injury that could seriously harm the health or function of the body. Um, Again, he's being charged with assault with intent to do great bodily harm, less than murder, or by strangulation. Uh, the court is satisfied as to count one based on the testimony of Officer Washington, that there is sufficient evidence that Mr. Morris did create an assault on Miss Nebraska by strangulation, uh, based on the testimony that was provided by 27C. So that count one would be found over. Count two being a misdemeanor will accompany count one. People are requesting to add a count three for additional assault by strangulation. Again, as indicated by the officer, there was a second incident that took place after the victim crawled into the other room. And this was the second incident that caused the victim to lose consciousness during the strangulation period. And so the court is satisfied that there is sufficient probable cause as to count three that will be added and bound over to the circuit court. Here's a count or request to add count four of witness interference. The defense is objecting, stating that there is no allegation or no evidence of bribery or threats. The criminal jury instruction here says the defendant being charged with a crime of witness interference, the people would have to prove at trial beyond a reasonable doubt first that Ms. Nebraska was an individual who was testifying or going to testify or going to provide information at an ongoing or future official proceeding. An official proceeding is a proceeding heard by a legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Second, that the defendant impeded, interfered with, prevented, or obstructed Ms. Nebraska from attending, testifying, or providing information, or tried to impede, interfere with, prevent, or obstruct Ms. Nebraska. It does not matter whether the official proceeding took place as long as the defendant knew or had reason to know that Ms. Nebraska could be a witness at the proceeding. Third, that the defendant intended to impede, interfere with, prevent, or obstruct Ms. Nebraska from attending, testifying, or providing information at the official proceeding. And fourth, that the official proceeding was a criminal case charging a crime with a maximum penalty of more than 10 years. Nothing in those criminal jury instructions indicate a bribe or a need for there to be a threat made. In this particular case, based on the testimony of the detective McBride and the exhibits that were admitted and played for the court did hear calls made from the Ingham County Jail from an inmate PIN number, from which each inmate having their own identification number, and not being at liberty to share that identification number for other people to make phone calls. There was a phone call during the time frame in which we know this Justin Morris, because we know there may be other Justin Morrises, was in the Ingham County Jail, and that the phone call was made to Ashley Nebraska at 548 Tisdale Avenue, Lansing, Michigan. Those phone calls that were played did give some information. One of the phone calls, the daughter's name was mentioned several times about putting her on the phone. We heard testimony previously that they shared a child in common with that same name. We heard testimony we had evidence through the phone calls of that which is alleged to have been Mr. Morris, saying that as long as Ashley doesn't show, they have no case, or no face, no case. And also indicating that he wanted her to not use her identification because he's gonna get in trouble and he doesn't care. He's gonna violate every time. Um, and also some colorful language as it relates to the prosecutor that's assigned to this case being Mr. Pfeiffer. So I think there's sufficient probable cause as to the count four, which is going to be added and bound over as to witness interfering. The court believes that there's sufficient probable cause that there was an interference, that the defendant interfered with or uh, prevented Ms. Nebraski from testifying as a witness in this case. And so that matter will be bound over to the circuit court as well. Bind over date's going to be December 14th. At a time to be determined by the circuit court. That's not a date that you need to appear in court. That's just the date that they get the file from this court. Your next court date will be a pretrial. You and your attorney, Mr. Sarts, will be made aware of that date. Do you have any questions at this time? Okay. I'm inclined to believe that Mr. Pfeiffer is ready to address bond. Is that what's going
Yeah,
on?
Your Honor. Your Honor, this defendant is currently facing a $10,000, 10% bond in this matter. I believe it should be $10,000 cash surety. He was on bond at the time of the offense for an unlawful imprisonment strangulation case with the same victim up at the 30th Circuit Court. We heard pretty explicit phone calls that he's continuing to make to her, where he's continuing to try and make sure she doesn't come to court, which is why count four was added. As a result of all this information, I believe it is appropriate for it to be a cash surety bond as opposed to a 10%. I'd ask that you modify it accordingly.
Mr. Sarts.
Thank you, Your Honor. Respectfully, I would request that the court just keep the bond where it currently is for the basis that in January, this case is going to be consolidated with another case that Mr. Morris is currently remanded on in front of Judge Arcolina. And at that point, I will, and I expect to, in the future, be having further bond motions. As it stands right now, Mr. Morris is very interested in potentially trying to get into rehab. And, you know, these are just allegations at this stage. Ms. Nebraski's statements were brought in through an officer. Mr. Morris has his constitutional rights during this process, including the right to have a reasonable bond. And, you know, the evidence itself here that was presented, you know, certainly this is just the first step in what will be quite a lengthy process. And Mr. Morris at this time, you know, is indigent. He would be unable to post either a $1,000 bond directly to the court, i.e. the 10%, or 10,000 cash surety. He does not have $1,000. So, but at some point in the future, Your Honor, this matter will be addressed again. And respectfully, just based on the evidence that's been presented so far, the allegations here would not be of a severe enough variety to warrant a change in the bond at this particular time. So, Your Honor, I'm just simply going to request the bond stay where it currently is. We will address the bond up at circuit court when the time is right in front of Judge Arcolina. Thank you.
Thank you. Bond was set at the amount of 10,000, 10% with victim notification on a GPS inclusion zone. That was back on October 20th. The allegations and the charges that have just been bound over, 4 counts, 2 of which are assaultive in nature, each carrying a penalty of up to 10 years in prison. Then also 1 count added for witness interference. These are very serious charges, and these are charges that to be taken into consideration when considering the reasonableness of the bond. I think that the bond as set is inappropriate, and it is too low. I will grant the motion, and bond will be amended to $10,000 cash surety. I'm also going to order that the jail block the victim's contact information. What's very concerning to me is that we were here on November 4th, and it was notified by the prosecution and put the defense on notice that they were assigning an investigator to this case because of allegations of contact to the victim as late as the night before the November 4th hearing, which is why the court had to find good cause to adjourn to this date. Then today I have to hear phone calls from November 8th, which was 4 days after that notification. We also have probable cause sufficient to believe that this defendant says his attorney's mad at him because he keeps calling the victim, but he doesn't care. And he'll do 1,000 years. He's not going to stop. He's not going to follow the court's order. Someone who is a blatant disregard for court orders is a threat to the public safety. And so the court has to take measures appropriate to secure the public and the victim at this point. And so I'm going to order that those calls be blocked and bond will be amended as previously stated. Any additional matters for the record?
Not from the people, Your Honor.
Nothing further, Your Honor. Thank you.
Thank you. You're off the record.
Thank you, Your Honor.